We got part 2 right here.
Is a Britain language, and it's illegal or against the law for two languages to reside on the same document. It is considered void at that point for non-disclosure of all facts. And they didn't disclose any facts. There's not a clean hands doctrine anywhere. There was never a meeting of the minds. It's an unconscionable contract. He has all his information. If he didn't think that this conditional acceptance weighed anything, why would he respond to it the first time, but not the second time? But the fact is, they don't have any proof, Your Honor, as far as, or any jurisdiction whatsoever over me as a living, breathing man. He knows that. I sent him plenty of cease and desist letters. I've yet to hit him with the color of law form, the violation warning, denial of rights under color of law.
You're talking about 1983 claim?
Yes, sir. I mean, like I said, I didn't file that. Or he doesn't even have a Form 56. He don't have a UCC 1 filing financial statement, which is mandatory to even get any claim from the court. He hasn't stated any facts upon which relief can be granted today. He's going off of hearsay. He doesn't have firsthand knowledge of a contract, which is necessary in order to bring a claim for someone. He's totally going off of hearsay and assumptions and presumptions. But I'm here to dead his presumptions and assumptions, again, with my power of attorney, which separates myself from that all caps, dog Latin, legal fiction, ens legis, transmit utility name. Now, again, lastly, Your Honor, I'll be done here soon. He's attempting to trial me under Arkansas Rules Civil Procedure 65.1, and that's security proceeding against surety. I'm not a surety, and the fact that I filed my power of attorney, I'm gonna have a copy of your oath here as well, and my public notice of assumed name. I mean, I'm filed with the county. They know that I am not the ens legis. But he's attempting to file and charge me under, again, 65.1 Arkansas Rules Civil Procedure, security proceeding against sureties. I'm going to go ahead and read a little bit of it and say, whenever these rules require or permit the giving of security by a party, and security is given in the form of a bond or stipulation or other undertaking with one or more sureties, each surety submits himself to the jurisdiction of the court and irrevocably appoints the clerk of the court as his agent upon whom any papers affecting his liability on the bond may be served. His liability may be enforced on a motion without the necessity of an independent action. The motion and such notice of the motion as the court prescribes may be served on the clerk of the court, who shall forthwith mail copies to the sureties if addresses are known. Now, I'm not in that position. I'm not the surety, Your Honor, so there's no way that he can try me under 65.1. I've made it clear that I'm not the surety. The court know I'm not the surety. It's on record that I'm not the surety. I filed my certificate of assumed name with the state. They know that I'm not the surety. All obligations under Title 31 of United States Code, Section 1501, it clearly states that all obligations are on the government. Literally all obligations, contract obligations, public utilities, pretty much anything because of the, can I have my water, please? May I have a water? Sure. Because of the House Joint Resolution 192, I believe, 1933, June 3rd and June 5th, through the Bankruptcy Act, all responsibilities are now on the government. I mean, that alone makes what he's attempting to say not my living, breathing man responsibility. Again, because they're not talking about my living, breathing child. They're talking about the birth certificate is what he's talking about. Lastly here, I'm sorry, Your Honor. And I'm just going to read one more thing here to prove that the burden is on the state and not me. The original birth certificate is the creation and the property of the state and in possession of the state, and further establishes the state ownership of its property and or ward known as Lexus Rochelle, a minor child. Now, it quotes, the State Register of Vital Records, the Department of Health will issue birth certificates, and that's under Smith versus Pavin. I mean, the corporate state of Arkansas case on behalf of the minor child is evidence of wardship in itself. So, and again, foundation required for admitting evidence of lay opinion is showing the first-hand knowledge of on part of the witness, and that's People versus King. And Your Honor, Mr. Todd, he's not done any of that. I begged him several times through his, through documents, basically, and my conditional acceptance, and he refused to come with any legal documents, any proof of claim whatsoever to hold me liable whatsoever. He refused. I mean, even if we were to go forward, we go to trial, or even if we go to trial, he will still have to provide these proofs of claims in order to be granted relief. So, everything he said is presumptive. Everything he said is not for the living, breathing man. I am the sole beneficiary, paramount security interest holder for the property and collateral of Willie Rochelle. I'm not the actual ens legis. I'm not the transmit utility. I mean, I understand how all that goes now, Your Honor. When I was in here plenty other times, I had no idea any of that. But now I do. I understand my position in court. And it's pretty much to go by the rules of civil procedure like you've mentioned several times, and that's what I'm attempting to do here, Your Honor. I'm not attempting to scathe the court. I'm not attempting to get over on the court. I'm not attempting to get from any responsibilities that me as a living man has. Because me as a living man, I take great care of my child. But what I'm not willing to do is accept a debt that should definitely be placed with the state according to Title 31-1501 anyway. This has been ruled on many times in the Supreme Court already, Your Honor. I mean, I'm not understanding.
Just to make clear, I think all of what you're saying is basically they're responsible for the child support because the ward is there. Is that correct?
Are they representing the state?
Well, I asked you a question. If I'm not correct, just tell me I'm not correct in what I'm understanding you're saying.
Could you please ask it again?
That the Office of Child Support, they're responsible for the child support debt that is owed, as you stated, because Alexis is basically a ward of the state. Is that correct?
Exactly.
Okay. Mr. Rochelle?
Well,